Dean, my name is Dane Max, and I am your Managing Director for the National Community Law Project CIC. So it's currently just approaching Sunday afternoon. So I'm going to spend a bit of time with you going through the National Community Law Project and what we do, who we are, what we do, types of law that we cover, and a bit of an explanation of, as we're going along, of my experience over the past several years as running this organisation and the many hundreds of students who have come through this organisation, as well as the many, well, over thousands of clients we've served and we continue to serve through this project. Okay, so brilliant. So, as I said, my name is Dane Max, and I'm the Managing Director of the National Community Law Project CIC. I'm also a co-founder, and we started this project in 2020. So the National Community Law Project CIC is a not-for-profit social enterprise that assists primarily low-income, marginalised and vulnerable people with legal support. So although we do charge our customers and we do fundraisers and as part of profiling, which you'll be encouraged to be doing as well, that's in order for us to cover costs realistically. We do charge, and sometimes we have to charge for our services depending on how the economy is going at the time. But other than that, we do very low, and that is really just to keep us going and to keep the overheads down. So that's basically how we work. But we're here to try to help as many people as possible with legal support. We're not solicitors, we're not barristers, we don't portray to be. But a lot of people, a lot of law students and graduates who come onto this program, as you'll know, will come on to get experience in different legal sectors and try and find out, what they like, gain some skills in actually helping people. But there are certain things we can do, and there's certain things which we cannot do. So we're not barristers, so we don't have right of audience as a factors into going in and representing people in court. We're also not solicitors, so we don't practice reserve rights under the Legal Services Act 2007. So we'll go through this as part of our training as we go along through the organisation, but many of you I know will be familiar with that anyway. So what can we do? So we're here to primarily provide legal education. So a bit of background in why I do what I do with the National Community Law Project and why it's been such a passion of mine. Firstly, there's no compulsory education in law in the UK. But unfortunately, law governs the way we live our life. And it's not just our civil responsibilities, but it's also our civil rights and how we engage with each other. Also, it interlinks with our fundamental freedoms: freedom of speech, freedom of expression, freedom of religion, freedom of choice, them type of things as well. So, coupled with as now you're more as you're more familiar as you're going along, you'll understand when you study law and when you've graduated that that education is actually a pretty substantial education. And it can be a superpower, I suppose, if used correctly and for the benefit of others. But remember, many people don't know this. So the people we serve, within the company, it works in a two-way prong. So the first reason why we set up is to ensure that we can get law students and graduates as much experience as possible whilst they're studying. So applied knowledge, so they can move forward. And applied knowledge equals wisdom. That's where wisdom comes from. Of being able to assist people in the most vulnerable areas. Now, that is one of the part of the passion why I was so passionate about this project, is because many people now cannot afford legal advice due to the LASBO Act 2012. So the LASBO Act 2012 restricted legal aid primarily in civil cases. So you can still get legal aid for criminal court to the majority of the extent. There's other things we'll need to cover at some point if we're going to talk about appeals and other things that can also provide problems for people in the criminal system. But you'll learn that as we go along. Um, but in civil matters, which is the broadest matter of legal, Unless people got the relevant insurances or they've got money spare, going down the legal route can be an extremely expensive route. So our job is to try to the best of our ability to get things settled without going into the courts. And the other issue is when they do go into the courts, we're limited on what we can do. So we can kind of help them with paperwork from their perspective and the stuff they need to put together, and work on things like that with them to try and make it as organised as possible and to educate them so they understand their case, which is our biggest job. And we can kind of assist them there, but it's a very bad way. The court should always be the last resort. What will happen is when you're on this project, a lot of the clients which we speak to will believe the court is literally the first resort to go to conflict. So they might have just attempted a bit of mediation and negotiation, and then they've haven't been able to get the results they've wanted for a variety of reasons. And then the next step then is issuing a letter for action and then going into court. That could be quite disastrous, as you'll learn as we go along. So we're there to kind of bridge that gap in order to assist people in a variety of ways, and try and be as flexible and adaptable as possible. And I want you to remember this term as well with flexibility and adaptability, because it's something we're going to be referring to quite a lot as we go through this, because these are some of the fundamental skills that solicitor firms and chambers will be looking for when you decide to further your career and move forward. If you do decide to do that, there's obviously other areas of law you can go into. You can go and work for a company in their legal department. You can also continue this kind of route, or maybe become a Mackenzie friend or a supporting advocate in them types of ways. There's many doors a degree in law can open, and there's a lot you can do with it. Hence the meaning of the word it being a superpower, because it applies to everyday things. So going back to the fundamental principle that there's no compulsory education in law in the UK at the moment, but law completely governs the way we live our life and the things that we do. So previously, before that, it used to be religion. So religion used to be the guiding principle. That over time have been replaced by law. The good thing with the UK is we've got centuries of law. So there's been a lot which have happened over the years, in order for people to really understand their values. We've got a strong history in legislation, hence why a lot of countries like to adopt that kind of principles as their own, the common law kind of route. Um, but like I said, it's not fundamentally it's not in education. And the law, as you're well aware now, which the law degree equips you for, has its own language, which a lot of people don't understand if they don't have that experience in law. So the issue, what happens is, if you can imagine, then they've got an issue and they think, I'm going to get a fair and just result. So you've got two parties going against each other, which we'll go into more detail with now. And they both think, right, I'm going to get a fair result for myself when I go to court, because that's what courts do. It's not really that simple. And this is the problem that people don't understand when they do start initiating court action or going into down that route. Is court is really the last place you really want to be with the situation, whatever, because even if you win the case, it doesn't really feel like a win. And we hear that time and time again, because what the law's got to try and do is balance things out for the interests of both parties to the best of their ability. There are times when they will strike out claims, and when there will be issues where one party is strongly in favour of the others. But the majority of the time, the judge is trying to get a fair outcome and a proper outcome for the parties. But on top of that, it's also an adversarial system. So it works in the way of, where it's not like Judge Judy, which a lot of people think it is, where you go into a court, like a state's court, and you have an inquisitorial judge who will sit there and ask you questions and get to the root of that kind of the court system in the UK doesn't work like that. The court system in the UK works on an adversarial where you both argue your case, or the parties argue their case, and the judge got to kind of make a decision. Doesn't mean the judge don't ask questions, but it's really to do with what you're presenting and what you're asking the judge to do based on the circumstances that have happened, and the rights and whatever rights and legislation backs up what you're saying. So it's a completely different system, and people get very confused with that. So you can imagine couple then with no standard legal education in law. There's no fundamental compulsory legal education. Coupled by the law has its own language. And this is what we come across a lot, and you'll come across it, where people will read something and they'll interpret it in one way, thinking it means one thing. But then we've got to educate them, and because of certain terms which are being used in there, we've got to try and tell them it means something quite different. An example of that would have been today. I've had something come through, and the client didn't really understand what it was and what the opposing party was saying, was there's no costs, there's nothing to quantify the costs, there's nothing which have been put in there, um, you know, um, but in legalese. So I've had to explain that and let the client know that there's got to be a schedule of costs which are included, because the judge got to make a decision on what the losses are, the costs, and then type of things as well. So without that being submitted, if it comes to the end, of the case, it can be extremely difficult then to get awarded any kind of costs or compensation or anything if you haven't really presented that to the judge. Now, the client would not have known that, because the client wouldn't. There's no reason why the client would have known that, as a person litigant. So it's understanding the context of that type of language as we're going along. So then you can imagine we've got a bigger increase of people in litigants as we're going along because of the cost crisis, because the courts are naturally a lot more expensive than people actually know. And the court's got very deep pockets, and a lot of people don't know this. They also don't know that, yeah, they can get help. So, say for instance, if you're on benefits, you can get a fee waiver, but that doesn't absolve you from costs if you lose the case or if you have cost impositions for not following the civil procedure rules or then type of things which need to be followed. So there's a lot stacked against people when they go persons and litigant, especially in specific areas of law, which we will discuss, and I'll shortly, and I'll give you some insight of my experiences. And there's certainly lots of. Sorry, I've just got somebody knocking the door. My dog's barking. And there's a problem with doing long videos because we always get interruptions of some sort. So I've turned my phone off, but I can't stop the door, so I do apologise. Okay, so yeah, so you got that, so you can see how it builds up. So then you've got no real legal knowledge. You've also got this language called legalese, which we know. And although we're trying to simplify that as much as possible, we still got to look through centuries of old English and everything else in order to be able to get this context in right. So it's going to take a while before anything like that actually happens, where it's going to be plain English, really, because we still got to refer to statutes and different laws which are decades, if not centuries old. Yeah, so then we look at that, and then we got the other problem then of when people actually hit the court system, then you've got the civil procedure rules. Now, the issue is, again, even if you're a personal litigant, you're still bound by the same civil procedure rules, making sure everything's on time, on a deadline, making sure that you're complying with the court in the correct manner and the correct respect, ensuring that you are actually following the certain guidelines for different civil procedures in different ways. So, and this is what a person litigant really don't understand until they file an M1 form or claim form into the courts, which causes them multiple issues because then they're in it. So if they file a claim or if they're a defendant to a claim. Excuse me for a minute. Thank you. So there's some of the issues. And the reason why it's so important for you to understand this and for me to explain it is because these are the type of things that will come to us. Now, luckily, the majority of people who come to us will usually come to us kind of midterm or at the beginning of something that an issue is arising. They'll usually come with the intent of legal action, but luckily, we don't get many who've actually taken legal action in the courts and then come to us. So that's a really good thing. But they'll always come to us with the intent of usually you'll tend to find with the intent of taking legal action against something for some reason. So we're getting a kind of picture here of how it works. So let's define the areas of law that people typically come with us, and I will try to give you some experience because, as I've said, we've literally dealt with thousands of people in the UK. We have hundreds of people coming to us every month. So you can imagine the amount of volume of work that comes in. So I'll start off with criminal law. So as you're very well aware, criminal law deals with matters with offences typically against the person and or offences where the state is involved in actually prosecuting somebody. So we don't really tend to deal with much things to deal with civil law. I'm so sorry, I'm just going to have to move my cat with criminal law. Sorry, I'll just move my cat for a minute. Oh, you idiot! Yeah, come on. Sorry about that. Didn't realise she was in here. Brilliant. So yes, so criminal law we don't really tend to deal with. We don't really get that many inquiries in there simply because legal aid is available for initial, so they can usually get some support somewhere anyway. However, we are starting to see a reduced a reduction in legal aid solicitors for criminal matters and duty solicitors as well. So some kind of, the courts are usually or used to have duty solicitors. The issue which we've got now at the moment is because in certain areas we have actually got legal deserts. So you hear that term coming up a lot lately and in the future, where there just isn't people who are interested in doing legal aid work. Because and usually down to the finances, they're not getting enough money for what they're doing. So it is called creating deserts, and some people just really struggle if they've got a legal issue to try and get representation that way. But that's something as well we're going to be addressing as we go along. So with that said, we're going to jump onto civil law. So civil law, as you're pretty aware, covers legal disputes between individuals and organisations rather than offences against the state. Civil cases usually involve compensation rather than punishment. So parts of civil law you'll come to, and I'll give you some examples now. So contract law. So one of the clients which have come to us. So I'll give you a couple of examples, so you know what to expect. One of the clients who come to us had a contract issue where they'd gone into a business. They decided to go into business with a business partner and move forward in as two business partners. The contract between them kind of split the company 50-50. And then and they had different duties they needed to do. So it was more to do with textiles, import and export. So one of the clients come to us, and then he was explaining that what he decided to do was they decided to separate, and then they made another agreement with a separation agreement that um, X will buy Y out of the business, and but providing there's no conflict of interest with the business. So they were looking at that, and they were hesitant to agree with each other because the issue was really around about non-compete clause. The issue is the one client was both clients had specific skills, so there was no way they could do a non-compete clause within. So that the non-compete clauses were don't be in the area, in the same area, and secondly, don't take any of the clients. So the issue was that he actually lived in the area, so, but he didn't actually agree that in the contract. So what he decided to do, and it was a term, for something like 2 years. Now, non-complete clauses don't really stand over 6 months, because courts tending to recognise now, and there was issues around this a while ago where they were looking to change the non-complete clauses completely, because what he was taking people out of work. But however, they agreed. So then he continued on, and then he set up his own business and decided to go his own way. But signed the complete course. Then he come to me and come to the organization. And then he explained that they were looking to take legal action against him because he'd set up the business and they believed that he was poaching clients. So we defined the fact that of any kind of client base they had. So that wasn't really happening, but he was actually trading in the area. So then it's a way up and it's a balance and of how do you navigate these kind of circumstances. So it was pretty easy for this client, or he when instead of setting up in that actual local area, he did set up a couple of miles away, and still worked, where he was working, but his location wise was a lot more wider. And things like that would have been a bit of an argument to get through. But anyway, there was you can see he was quite disgruntled and quite vexatious. So after a bit of negotiation back and forth, they did actually back off, and that contract dispute just kind of died away, because there was no real aim in it, other than either trying to get money from the other one or trying to prevent him from doing business from our client. So it's that kind of contract as well. We've also had contracts where we've had builders come to us, where we've had a builder come to us, and their contracts were literally null and void, and they were literally typing them up themselves. And so there was a like kind of offered acceptance, intention to make legal relations a consideration. However, there was a lot of things that were left blank. So such as scheduling and how they're gonna work out what they're gonna be doing to the property, and how they're going to communicate that, and indemnities as well wasn't there. So there was a lot of things that needed to be done. And this person had 12 companies, 12 building companies, each in different areas, and also doing some different things. So we had to restructure the whole contract side of his organization to his specific needs, but making sure that they were actually standard form contracts that could be used properly for the 12 businesses, but making sure that they were all specific in that kind of way, as well as making sure that he had everything else in place that he needed in order to progress. Other types of contract we'll have is if a consumer contract, for instance. And that usually they're done via telephone, but you still get the basic principles of the four, offered acceptance, consideration, and intention to create legal relations in there. But it would probably be through a text where they wanted something new, or they've gone into a shop and they purchased it under the Consumer Rights Act, that kind of thing, or they've gone online and they've kind of made that kind of purchase and then found out that it's been defective of some sort, and see what they can and see what they can do. So we get quite a lot of that as well. But that all kind of falls under contractual disputes. But all of these stuff have been able, and so the reason why I'm highlighting this now is just letting you know that all these kind of contracts, things we've done, have all been outside of the courts. Failing that, if there is a contract or a small claim, so we have different tracks within the court, and they're all based on the amount of money that is being pursued, but they all have different procedures to follow. So you get the small claims track, which is up to 20,000, and then sorry, it's up to 10,000. I apologise. So it's from 0 to 10,000. You have the fast track in the courts, which is from 10,000 to 25,000 typically, or maybe 30,000 sometimes. Really depends on the judge's directions. And then anything over that goes on to the multi-track. Now, the reason why they're set up that way is because the volume of money is usually a lot more that the person is trying to seek. And there's different procedures that need to go to get involved that need to be done, such as disclosure, where it's small claims is pretty straightforward. Fast track, then you're thinking about different things like making sure disclosure is happening and following the judge's directions from the initial directions hearing of how this case is going to plan out and move forward. And there's also some delays in court as well. So people also expect it to sometimes be quick or not realizing how long these things can really drag out for because of the backlogs that generate within the court systems, especially in different areas. So if there was a small claims track, so just for instance, if for instance that contract, if we had a contract, where somebody's had a defective item and they paid a couple of £1,000 for it, it goes onto the small track. They want their money back. The other person just outright refuses to give them their money back. So they'll make a claim under the Consumer Rights Act. The thing is defective. So they need to take some video, they need to take some photos, they need to have proof of purchase and other things. Then they would typically file an M1 form. The M1 form then would be submitted accompanied by a particulars of claim. The particulars of claim, and then there would be probably a witness statement that would accompany that as well, and then a schedule of loss. So pretty straightforward, just explaining to the judge what has happened with this and why you're coming in order to get a judgment in order for this defective item, for instance. So that's just an example of the procedures there if they go forward. But typically, our job is to always try to try to get negotiated out of court and try to equip our clients with the knowledge and wisdom in order to try to deal with it in the best way they can and equip them with the knowledge, such as negotiation skills, maybe even mediation, them type of skills, all type of ADR to keep that away. We also have things like tort law. So tort law covers, as you're aware, negligence, defamation, nuisance. So the issue with with tort law, so we're looking at everything from boundary issues. I'll give you an example of one which would fall under tort law. Would be the clients which have come out, which is under negligence law of come out of an hospital, out of the hospital. He was walking around and tripped over a step that was raised higher and then the second step, and he kind of tripped over both of them and ended up falling and really damaging his leg. And he had to take time off work as well and have plaster. I think it was like a broken ankle and some other stuff like that from my recollection. So that would be negligence on the behalf of the local authority because the local authority had the issue where they were where they had to provide safe roadsides. And you tend to find a lot of these kind of claims these days, personal injury claims, that kind of stuff, and it's all based around the negligence. And we all know where negligence started from. So I'm just gonna let you remember that one, and I'll just mention slug in a bottle. So have a think about that case. So yes, so we get some negligence there. Other things like nuisance will fall under tort. So where people basically just aggravating people's peace, especially on land. Somebody keeps coming, visiting somewhere they shouldn't be visiting. They've been warned, they've been told not to trespass, go away. Or even worse, coming and providing being aggravating as well. So providing aggravated trespass, such as being a threatening behaviour, that kind of stuff. They tend to fall under tort, but they can become criminal clearly if there's like threats to life, health, that kind of things. But people's right to land and people's peace to land, it's a really big thing. And you tend to find that more in the more, you tend to find them kind of issues need to be highlighted and become more like in more affluent areas as well. And they've got a very territorial, and tend to see the people from in affluent place where they're really looking after their properties, they're buying their properties, got a real big thing about territorial land. So, but that might just be my own personal bias. Then we've got property law, so we'll get a lot of property law, everything from landlord to tenant, to people having their own mortgages, and property law falls into a lot of different into a lot of different categories in itself. It's a world in itself. They all are really, but you'll tend to find with property law. So, for instance, you'll have landlord and tenant where you could have a landlord trying to contact us, wanting to know about how to deal with a tenant who ain't fulfilling their duties properly, such as maybe not paying rent, not looking after the property, maybe creating nuisance to other people, and they'll want to know how to navigate that situation. Antisocial behaviour issues, especially with local authorities, or we'll have a tenant who'll come to us and explain that the landlord ain't doing their jobs properly. So where they've left the house in disrepair, they haven't maintained the property to the standard it needs to. They might not have a gas certificate, which is really important, or they might have a low grade gas certificate under an E, like a G or H, which means they can't even let out the property in certain places. And there's also going to be other issues such as like trying to evict them. So issuing them a 21 notice, section 21 notice, which is a no fault eviction, which the landlord just wants their property back, which usually takes a period of time. You also got to know the difference as well in England and Wales law now since 2020 that the typical Housing Act have been replaced by the occupational contracts now in Wales under the Wales Land Act, which is quite different. It actually gives quite substantial rights to tenants now, making it harder for rogue landlords technically to evict people or reduce their rights whilst they got on the property. So they are substantially. There's a lot of difference within them both. So if you're ever dealing with the Welsh law or Wales law in comparison to England law, English law, and that is something you'll need to highlight as well. We'll also need to highlight the differences between Northern Ireland and Scotland as well. So then we'll have tenants which will come in, and then they'll have other issues such as if there's boundary issues and like them kind of stuff, and that them believing the landlord ain't doing things correctly. Other things such as an increase in rent. They could also be issuing a Section 8 notice. Now, a Section 8 notice is to try and get somebody immediately evicted. They're usually quite harder to obtain, but sometimes landlords can find rights in order to get people evicted immediately. Now, you can imagine the kind of complications that can cause for somebody who's a tenant, and especially if it's like a kind of malicious thing, that'll happen. But you'll come across a lot of issues when it comes to landlords and tenants. Other housing issues such as mortgages. So we're going to be looking at, and you'll have clients who will come in who will have issues with forced disclosure, forced. No, words will come to me now. Sorry, I'm getting a bit stuck. Where a client, where basically the banks look at a repossession, sorry, a repo, where banks are looking to repossess mortgages because late mortgages are payments. We've had clients who've been in arrears everything from £5,000 to £30,000, where banks have looked on foreclosure and looked on being able to sell the property. And obviously, banks have got a lot of rights, or finance companies, not just banks, in order to issue them. So then it's how to navigate them kind of situations. We'll also have marriage issues where you've got joint tenancies, joint tenants or tenants in common, and they decided to separate, and then you've got the whole issue then of how to divide the asset. Typically, it will go 50-50, but then it's got to be sold. There's other things that need to be put in place as well. But there are other circumstances where it won't be that amount. So we get them kind of issues as well. And also probate, we don't really deal with probate because that's a reserve right. But for information purposes, if you're looking at somebody who passed away, and then you've got another issue with it that's quite prevalent, and there's multiple siblings, and they all got different ideas. So, another client we were speaking to just a day or two ago, he wanted to separate. So they had the property that was two properties. He wanted to separate the two properties and make them two properties. So then when they sold, they would be more flats because one side had, from his explanation to me, had all the amenities, a kitchen and everything else, and then the other side also had the same thing. So they could have actually partitioned it and turned into flats accordingly, which would mean they would have got more money for it. But however, his brother wanted to live in the flat and the sister wanted to sell it as a full house. So you can imagine what kind of complexities that had. Now, the issue with them specifically, for this family, and obviously I can't mention names, or let you know who they are, but the issue that specifically they had is they were all executors. So there wasn't just beneficiaries, they were all executors of the property as well. So that's really one of the ones which will have to go to court. And maybe appoint an independent executor who can oversee the interests of everybody, which would make it a lot easier and probably a lot cheaper as well. Um, Yeah, so there's some examples of the property side of the law. You'll also have a lot of commercial properties. You'll have tenants in relation to commercial, and how them contracts differ in ways of duties, responsibilities, and shared ownership, all that type of stuff. So it's a really big learning curve for people who ain't experienced in that. Okay. Family law is one of the biggest we will receive within the organisation, and there's some family law we can assist with depending on the level of complexity, and there's other sort of family law that we just really need to refer on. So a lot of the family law cases typically get referred on with us unless we got somebody who's highly competent and in that kind of area. So family law ranges from so many different things as you can imagine. But typically the strongest one, well, the typical one the most emotive is usually roundabout child arrangements. So that's typically where a couple have usually split up and because of their issues, then it's sometimes whether it be by whatever parent, instead of going 50-50 and negotiating things where their relationship becomes strained so much it can really affect the child. So, and it also affects the rights of the child as well. So then some things which we'll have is where a mother or a father can try to refuse access to the other parent, and or other issues where they try to impose different things such as, okay, well, I can only have them this time every 2 weekends, or every weekend, and then you have the bulk share of the parental responsibility. Or other amicable things can be is if there's other people involved. So typically, if somebody splits up with that, so if a family or a couple split up and they go with they have another partner, or there's been like some kind of affair or matrimonial issue, and then the other parent don't want the child to be involved with the other person. So, and there's multiple ways. It can even be down to grandparents. We've had cases of that before, where the grandparents have actually tried pursuing a couple because they've actually fell out with with one of the children and their spouse, and then tried to pursue the actual claim to actually see their child and try to assert some kind of grandparents' rights over the child, when the both parents adamantly did not want that to happen. So there's a lot which happen with them. Um, the issues which we have got to be careful with family law is it's really emotion. There's a lot of emotion involved, and it's really administration heavy. So a typical process, say for instance, if somebody wanted to see their child, would be to file a C100. Before they file a C100, they'd have to attend mediation and get certification that mediation wasn't effective, and try and get that rights. And then it's the enforcement of the rights. And so once it's actually granted by the courts, because the courts believe that every parent, obviously, to keep the family together, but the child's welfare is always paramount, as in the Children's Act. That is just to make sure that um, that's there in order for them to be able to assert their rights. And there may be conditions to that as well. So if there's been issues around kind of domestic violence or issues that could potentially harm the children, then it might start off at being a contact centre or some kind of visitation where there's other people present, which isn't typically too good for the opposing parent. But that's the court have got to make those decisions in order based on the information which they've got, in order to protect the child. And sometimes it can be as straight as, or one of the parents or a trusted friend will pick up the child and drop him to the other people, or they can work it out themselves. So that's like a typical kind of example, but they can get very complicated very quick. And how they start off cases as well is something which is however simple they start off, they usually don't end up simple as you go along. They end up getting more and more complicated. And it's up to if we're in support of providing like kind of feedback or counselling or some support there. We can always try to guide people to legal support and for solicitors and barristers, but generally if people cannot afford it, then it's down to conditional fee arrangements if they can do that, or damage-based agreements, or conditional fee arrangement as well, is where a solicitor will turn around and say, okay, we'll do a no-win, no fee. So then if we succeed in the case, we'll get X amount we'll apply for our own costs and we'll do it that way. Or damage-based agreements, where if there's high stakes damages and the case is extremely strong and the solicitors are confident there, but they can select them. But there are other different things, flexi pay, installments, and other kind of things. Some solicitors um, are trying to implement in order to get more people on board. But what solicitor firms tend to typically have high costs, so they need to make sure that their costs are being met in order to do what they need to do. And that's a huge could be a huge problem for people who pose as litigants. There are also kind of things like private funders, and there's legal fundraising out there, where people will actually back a case, but it's really dependent on whether that organisation who runs them funders are happy to take on the case if they believe it's going to be that big win. And there's also insurances like legal expense insurance, whether you're a business or whether you're a homeowner, that might be able to cover some costs depending on the circumstances. But typically what the person that's getting is up for us to try to educate and try to find out, is there anything that they can kind of do if we can help them that way, if they do need legal representation, and help, and then try to reach out to the relevant firms to see if it's something that they'll take on after we do the research and move forward with that. But typically, if they're in the case themselves and they've got a lot of things which are actually going on, with the family courts, it's best for us to try to keep them on track as much as possible so they don't lose focus, especially when they're going up against very tactical and very experienced barristers, solicitors. Luckily for us, as an organisation, we've dealt with hundreds of barristers and hundreds of solicitors as well. Solicitor firms, so we're very, very smart on, what kind of tactics people are using, if they're using tactics or whether they're just generally trying to do the right process and then kind of things. But you'll pick up all them types of skills as well. We become very, very smart very quick. Doesn't mean we know everything, but we can be a lot more confident with experience, because with knowledge and with experience comes wisdom. So that's the whole point. You get the knowledge from law school, you get the experience for us, gives you wisdom. Okay. So employment law as well, that's another increase we're seeing at the moment. We're seeing a lot of people, coming under employment law, with issues around happening with employment for a variety of different reasons. Um, there's a lot of people at the moment who have signed up to specific roles, and they don't feel like they're being treated fairly, or there's some other issues. So one of the main issues we do come across is breaches of the Equality Act 2010. Now, as you're probably well aware, the Equality Act is set up so it's all the disability acts of previous years put together to create this Equality Act that gives people with protected characteristics the ability to be protected. So it falls into 9 categories, and in some of the categories we're looking at is age, race, we're looking at gender, sexuality. We're also looking at disability, and pregnancy as well, is another one. So there's a few they hit, age. And the whole point of the Disability Discrimination Act is to prevent discrimination primarily, anywhere in life really, but primarily from employment or statutory bodies, making sure that people are treated fairly and equally. So regardless of the issue, the protected characteristic, if you took that, so what how the Equality Act look is if you took that out of it, if that was protected, so people could not discriminate against you because of that, would it give you a fair advantage? And unfortunately, with workplaces, because there is so many different types of people put together, it's extremely difficult sometimes for employers to be able to navigate them. So they implement, and this is the point of implementing policies and procedures of working. So everybody knows, number one, not just under the Equality Act, under the Health and Safety Act, and things they need to, people need to know, and how people need to navigate, and how everybody is responsible for everybody else's safety, is really paramount. And then you've also got other policies which are in place as well, is not to discriminate, formal grievance processes which need to be implemented, such as so if there is any kind of dispute or issue, that it can be managed effectively. But then if you've got an organisation that's full of many hundreds, sometimes thousands of people, and you've got different departments who split down, it's a huge HR job to bring in all of the correct policies, the correct procedures, and the correct things in place in order to make sure that people are trained to the best level, in order to not discriminate against other people and understand what discrimination is. And typically, discrimination is just treating somebody differently. So if you're being treated differently, and you perceive, because it's down to the perception of the person who is highlighting the disability discrimination, you could be put in a you could be put in that situation. Now, with myself and a lot of the people who've been in this organisation, we are very, very passionate and strong advocates for protected rights and looking after people who are more vulnerable. So it's something that we advocate for. It doesn't mean that we're not objective, but it's also making sure that people understand that the communication needs to be clear to move forward. Also, what we just touched on was the Health and Safety at Work Act, another big area as well. So, employment law needs to be protected as well. For instance, if somebody has an injury in work, for instance, falls on the stairs and needs to bring a claim or isn't covered under the relevant insurance, and it's down to the actual employer, then all the responsibility is under the employment umbrella. Then that needs to also be taken into account so the person can be effectively compensated, especially during the injury or if the injury has any long-term effects, so they can be protected there, as opposed to having employment issues after. So I'll give you an example. One of employment discrimination is a ex-serviceman works in an organisation, been working there for a few years. New manager come in, and the client who came to us was deaf, and then he had remarks made about him, basically about his deafness by the manager in a meeting, which he wasn't a part of. But it was only because somebody else came, or another senior person came and said to him, "I'm putting in a complaint because he just said this." He actually submitted a formal complaint on behalf of of our client, and then literally within a month, the actual manager who made the accusations tried dismissing our client. So you can imagine what kind of impact that would have had. Obviously, that was dealt with quite rapidly, and you can imagine the impact that would have had because the organisation had to act. Luckily, they were a good organisation, and they didn't tolerate that kind of behaviour. So that kind of worked out really well. Another issue which we had with employment, sorry, employment law. So there's multiple issues, but obviously I'll just be selective. So a personal injury, somebody actually went into the office. There was a slip and trip where a third party organisation was hired to do the cleaning. Done the cleaning, didn't put any signs up. Our client came out of the toilet, slipped, ended up really doing quite a lot of damage, and then had to be off work for a couple of months and then come back in. So that was a third party claim. So initially it was against the employer. The employer took out the indemnity, and then the indemnity was dealing with then the actual company that was that the third party company in order to indemnify the client in order to recover costs for the injury she sustained, whilst the company also looked after her to make sure that she didn't suffer loss, financial loss specifically, and had the right resources and support. So that's another example of a company doing really well. Excellent. So there's some examples of employment law you'll come across. Now, employment laws typically ain't dealt with in the courts. They can be if the client selects, but they're typically dealt with tribunals, and they operate quite differently to the courts. So with employment issues, it's usually so if there's a dismissal involved or there's a kind of grievance raised that haven't been dealt with effectively by the organisation, then it's typically a route to a union, and we should really advocate for people having unions, and some are better than others, and again, making sure that if clients got like legal expense insurance as well, that usually typically covers employment issues as well. However, the standard route is putting a complaint to the organisation. If the organisation don't respond properly, then it goes through the ACAS system. And what ACAS does then is it tries to act as a mediator so both sides know what is going on. There's nothing really ACAS can do outside of that. So ACAS don't really do, they're not going to inform you or give you any kind of legal advice or that kind of thing. They're just going to act as a mediator. And then if it isn't resolved and it does need to go to the tribunal, then there's a certificate issued, a conciliation for early conciliation, and then that's basically sent then to then that's sent to and then that's sent to the company, and then a tribunal is filed then to hear the grievance and to make a decision based on that. Again, that can be very administrative heavy, can be quite intense when it goes there, especially if there are people in litigant. And then it's the different areas of law which are looking to go through. Okay, so I think that's enough on employment law. So it's just giving you a taste as well. And then you're looking at commercial law as well. So we do get commercial clients who come in. Commercial clients typically, and this for law graduates and for law graduates and law students who are looking to actually work as an extended part of a commercial team, and where we'll be looking at things like we discussed earlier, contracts, making sure, and so this is working directly for the organisation. Now, organisations themselves are actually starting to recruit quite heavily in the UK, legal people as a part of their organisation. So legal law graduates and law students who can assist them with contracts, policy drafting, maybe dealing, being an intermediary, being an intermediary between places like HR, employment, accounts, them type of things. If there's issues that are arising, so policy drafting, contract drafting, also maybe dealing with difficult customers with complaints. So if there's a kind of complaint that comes in from an external source, they might just have you or a handful of the team who will go through that information and make sure everything's done right in a way that positions the company in the strongest possible position, whilst maintaining customer satisfaction where we can, and if it cannot, then just limiting the impact that that's going to have on the organisation. We'll also have other things like regular insurance reviews, making sure that that any kind of if there's kind of mergers or transitions happening with external firms, external legal, that you're fully informed, you know every step that is going on, and you're basically there to protect the business to the best visibility, but also make sure the company is operated to the highest standards possible for the clients and for the customers which they serve. So there's a lot which we can go into with commercial law, but we do get that as well, which comes in. Public law, that basically, as you're probably well aware, so I'm speaking, obviously I'm speaking to a lot of people at the moment through this video. So constitutional law, so we're looking at the constitution, so we're looking at and it usually combines with administrative law as well and the Human Rights Act as well. But we're looking for breaches within the public sector. So as you know, another thing, this is another area that's constantly increasing at the moment, where people are having issues with local authorities, local councils, local hospitals, even down things like public libraries. And it can be a range of different issues, such as if somebody owns a home and they believe that the local authority is trying to is encroaching on their land, for instance, like maybe building a street or a pathway or putting a bus stop outside, which we've had before, right outside their house, that kind of thing. It can be other things such as council tax, a big thing. A lot of people complaining about the issues arising with the enforcement of council tax and the enforcement of things which is becoming quite a concerning area at the moment, from what I'm hearing. There's also the failure of duty as well. So, for instance, if you've got somebody, for instance, who's been evicted from a council house and the duty to not make them homeless. Now, in some areas, there are also not much support. So people have to travel to other areas to get support, such as night shelters. So again, we had a client who was evicted from temporary accommodation, but failure to safeguard because the person was also disabled. And remember, it's a stronger duty as well with local authorities. They've got a public sector duty in the Equality Act in order to safeguard people with disabilities. And the fundamental problem is with the local councils and local authorities is the people they hire. The people they hire are not legally trained. So they only know there's an issue when somebody like us or a solicitor or a legal representative of some sort or a legal aid charity of some sort or legal support charity will get in touch with them. Again, we've got to treat them like persons and litigants who don't know the law. So they won't know there's an issue until the issue actually arises. So what have happened is within this, and it is their job to know, obviously, because that doesn't prevent them from being subject to claims being submitted against them. So this gentleman who's disabled was evicted from over on a Friday evening, was evicted from his property, from a temporary accommodation, and was literally put out on the streets. Now that failure to safeguard, because realistically then they should have put him in another accommodation whether it's a temporary accommodation or a homeless shelter for the time being, or give him the options to do so. They failed to do that and left him literally over the weekend. And then he obviously contacted us, so we contacted the Samaritans and multiple other people as well to give him as many options as possible. But over that weekend, they couldn't do anything till Monday. So that's a failure to safeguard because when you're in the middle of winter, the last thing you need to be doing is sleeping rough on the street when you've got a disability. So yeah, not very good. So there's a lot of things which come through with the public authority, especially lately as well. There seems to be an increase. A lot of people are getting very dissatisfied with public sector services, not fulfilling the roles and duties they're supposed to fulfill. So yeah, we'll have a lot of things like that coming in as well. So yeah, and then so we'll have them type of we'll have these type. We'll also have things like intellectual property, which is kind of a specialized area. But we're looking at brands, so we're looking at copyright. We'll be looking at copyright, trademark, patents, infringements against them, and then how to navigate them type of situations under intellectual property. Um, and we'll also be looking at we'll also have quite a bit of EU and international law. So if we're looking at human rights, for now it's still under the European Court of Human Rights. I know there's been talk about trying to remove it, but that talk's been going on for decades. So I'm not going to see that. I don't think that's going to be anytime soon. But at the moment, then you can see the crossover then between the EU and the States, and also other international law as well. Because we're also global, we've got big issues. We've had a lot of people who've come to us and they've been, I've bought a property here, and I had it funded here, for instance, but then I found out the company that I was actually funding it was from Canada. Or we've had people where they've hired a service, say, for instance, off, I'll just use an example like Amazon, but they've hired it from the US department, they haven't been in the UK department, which causes a range of cross-jurisdictional issues because laws are different. So then it's like what law is actually going to apply. Obviously, with Amazon, it would be UK law because they're also based in the UK. But then there's also there's other avenues. You need we need to look out, and there's a lot of cross jurisdiction now. And then it's so which party is going to be the accountable party? Typically, it's where the client is based, but not always. So there's a lot to learn there. International law is going to be really a theme. You as future lawyers and barristers and business lawyers and whatever department you can go into, it will be dealing with more and more and more. Because the jurisdictional lines are getting really blurred now moving forward. Example of the crossover itself, we had an issue at one point where we had hired the service. The service was through a local company, which we actually found out then was actually a company based in Southern Ireland. So there was some cross jurisdictional issues there. The company actually sold done a merger, then sold to another company, and then the services which we had was kind of restricted. Can't go into too much detail about it, obviously. But it led to me having to actually reach out to the CEO of the organization and come really close to legal action. But then they ended up paying us out. So yeah, so that was extremely annoying, as you can imagine. And then we've also got environmental law, which is another really big department. I'm not going to go too much into environmental now, because I think I've gone through enough. We're something we have, but it's something we don't have that much. And then we've got immigration and asylum law. Now, again, another huge increase here, where people have come over. Have either lived in the UK, and if they've been living in the UK, for instance, and then they've married somebody outside of the UK. So we've had issues where that have happened, they've got together and then they need to try and get a spousal visa, or they've got married, they've come to the UK and then they split up. And then we have the other people who are contacting us to try and see if they can stay in the UK because they've had a child together. So there'll be issues around that. We've also had where people have got married in another country, and that they've got married in that country and then they come back over to the UK. One of them's a UK citizen, the other one isn't, and then they've got together and they've got a spousal visa, then they split up. So you can see the kind of cross jurisdictional issues we have there. So this and then how do they stay in as well, So we know that there's a lot of changes with immigration at the moment, and we're very limited on what we can do because there's actually grades to actually deal with immigration. So from an information perspective, it's fine. But if people really need to act, and they really do need to have somebody who is certified in the UK is it's regulatory to have for somebody to work on that. And it's a rapidly changing thing as well in the UK. We'll also have people here who work and then where they're skilled workers at the moment. And obviously the skilled worker visa have increased, the amount, to stay in the UK have increased. Where does that leave the current skilled worker if they're not making that amount of money? Or if somebody else is coming in or they decide to go into another job, and it's paying less or it's not as skilled as where they were before. Also, if they're on a student visa, what's the rights in order to move forward, in order to become a permanent resident if they want to work in the UK. And then we've got all the other things coming into it, and people coming over to the UK who haven't entered the UK correctly. So we get all these types of issues as well. And again, it's another increasing issue because of the changes with the immigration system, and something to make sure that people can, how to navigate that, how people can navigate that as well. So, so I hope that gives you an overview, Annika. And I know we've been talking for a while now, so I'm going to jump off, but it just gives you an insight of the type of things. And we're really only touching on a couple of subjects as we're going along. As you'll see, as you'll expand it, a lot of different issue comes through, and every issue in itself is unique. And we receive literally hundreds of people looking for legal support every month. So what that is where that is where we are at the moment. But I hope that gives you a kind of insight of the National Community Law Project and what you're signing up to, and help you understand the type of cases we'll come across, and highlight the issues that as you go along. Thank you very much, team, and really good speaking with you. And if you need to know anything more, just reach out and let us know. Thank you.